All right, it is 1:15, and we would like to keep time and hopefully have a little bit of time for question and answer. So we're going to open the session. Please feel free to come as close as you would like so that we can have a conversation rather than a declarative meeting. But I will immediately welcome everyone and thank you for being here in person. I also understand we have over 100 person online, so we are on air and quite well attended. And I would like to start by giving the floor to the Ambassador of the Kingdom of Belgium, Monsieur Olivier Belle, for his introductory remark, and first thanking Belgium for the constant and sustained support that you bring to the issue of conflict-related sexual violence and accountability for such kinds of crimes. And you have the floor, Ambassador.
Thank you very much. Good afternoon to everyone in this very big room, but I see that there is a lot of people interested here in physically, but also I think online. Huh? Thank you. Enslavement and conflict-related sexual violence are forbidden by a number of treaties and by customary international law. As we will hear from the experts today, many international legal regimes which criminalize these conducts have developed over the years. To make sure that these regimes align, it is important to further focus on the nexus between them. Today we will hear from experts in the field how we can deepen our understanding of the interplay between these legal regimes and their ability to address the true criminality of those conducts. Recent conflicts around the globe serve as stark reminders of the atrocities that occur in tandem with war. Sexual violence, trafficking, and slavery represent severe and some of the worst violations of human rights. The recent experiences in Iraq, Syria, and Ukraine underscored this harrowing reality. As outlined in the Security Council Resolution 2331, we recognize that these crimes cannot be studied or prosecuted in isolation. Their interrelatedness necessitates a holistic approach to understanding and addressing them effectively. That is why during today's side event, we plan to illuminate the key issues discussed in recent publications and develop greater clarity on the connection between these various legal frameworks. The insights we gain here will be important in our collective fight against impunity. Ultimately, our goal is to discuss how we can enhance prosecution effort and ensure justice for victims. Belgium is committed to fight against human trafficking. The Belgian government considers it one of its priorities and intends to step up the fight, focusing on 4 perspectives: protection, prevention, prosecution, and cooperation. Over the last 20 years, women and girls continue to represent around 70% of detected trafficking victims. We need to maximize efforts to enable their agencies for change, facilitate participation for and meaningful inclusion of women and survivors at all levels of decision-making on relevant policies and services. Survivors should be at the core of all our discussion and effort. As a form of violence against women and girls, and taking into account the high incidence in conflict and post-conflict situation, it forms an integral part of the Women, Peace and Security agenda. As such, it is integrated in the Belgian National Action Plans on Women, Peace and Security, with concrete actions for the Belgian Police Service, Defence Forces, as well as on the protection and support of victims. Trafficking in human beings should be addressed from a cross-dimensional perspective with human rights-centered and gender and age-basis approaches, given the multifaceted nature of this crime and the diversity of profiles of the victim, with a special focus on child trafficking. I would like to emphasize, concluding, that the fight against conflict-related sexual violence, trafficking and slavery must engage a multitude of voices. It is crucial that we forge partnerships among government, international institutions, civil society, and academia. The UN team of experts on the rule of law and sexual violence in conflicts will guide us through this side event today. Thank you very much.
Thank you so much, Ambassador, and thank you to Belgium for, as I mentioned, the support and for hosting us today. I also want to apologize to you because we do not have name tags, so I will try to make sure that we are very articulate in how we present people so you know who is actually speaking. We also would like to thank Impact, and in particular Anne-Marie Brouwer and Effie Devolder for partnering with us on this issue and co-directing the Journal of Human Trafficking, Enslavement, and Conflict-Related Sexual Violence, along with my co-moderator, Patricia Sellers. And we will be discussing some of the work of the colleagues today and unpacking this issue. I think, as the ambassador mentioned, the idea for being here today and having this discussion is a bit of a long-awaited implementation of a 2016 Security Council resolution that recognized the link and the nexus between trafficking and conflict-related sexual violence. This was in 2016, which was almost, not quite 10 years ago, but we need to unpack this because we need to implement the political commitment that was made through the Security Council by the international community and the member states in terms of delivering justice and accountability for victims and survivors. The idea of today's meeting is trying to walk us all through a quite intense intellectual conversation of unpacking, as the ambassador mentioned, several different siloed, generally speaking, legal frameworks, and looking at how we can adopt a comprehensive approach to actually reflect in real life the complex conduct of these crimes and fully understand and harvest the offenses to the best of our practical ability so that victims actually have a victim-centric approach and victim-centric response of justice to their plight that recognizes the multitude of harm that they have actually suffered. So as the United Nations team of experts on conflict-related sexual violence and rule of law, we have embarked on trying to actually work with international experts around this panel to do quite just that, and also looking at tooling the practitioners at the domestic level and international level to be able to operationalize the political commitment made by member states. While we, of course, understand the importance of the resolution 2331, it will only really take its full reality when we can actually make use of all existing legal frameworks to ensure the fulfillment of this resolution for a better justice for victims and survivors. And in terms of moving us forward to that, we asked in 2023 Anne-Marie de Brouwer and Effie Devolder to advance our understanding of how the legal concepts are associated by conducting a study which was prompted by the Ukraine context, looking at, that nexus happening before our eyes, and building on the contextual understanding that was gained through the work that we've been doing all, and the sustained attention we've been putting on contexts such as the Boko Haram context in Nigeria, the Al-Shabaab context in Somalia, but also obviously the ISIL-Daesh context in Syria and Iraq, where those were for us, in terms of conflict-related sexual violence and conflict situation, the epitome of how we saw the conduct being really embodying the nexus between the different dimensions of this harm and crimes. Earlier this year, the team of experts also convened the first international conference of prosecutors focusing on conflict-related sexual violence crime. And in the discussions we had amongst the practitioners, what came out very clearly was there was a serious impunity gap for these specific crimes, and a number of challenges that practitioners encounter at their own level in terms of the prosecution of these conduct. And those included a lack of adequate legislation, conservative judicial practices, particularly related to how to charge these crimes, challenges in the investigation and prosecution of these crimes, and the existence of institutional silos. And finally, but quite importantly, also a lack of adequate protection for victims and survivors. So as a result, we embarked on this study, but we also partnered with those who have been working on this for quite some years, and particularly I'm referring to all of the panelists and the special edition of the Journal on Human Trafficking, Enslavement, and Conflict-Related Sexual Violence, which have produced work that are invaluable in terms of the contribution for national prosecutors to support their work in doing better in advancing accountability for those crimes and justice for survivors. I will start by giving the floor to my co-moderator, Patricia Sellers, who is also the special advisor of the Office of the Prosecutor of the ICC on slavery crime, and who, with Anne-Marie and Effier, co-edited the special issue on the nexus between human trafficking, slavery, and slave trade. And on Monday, as we all know, Patricia, presented the new first policy on international slavery crime. So as a preamble to the discussion we'll have on the panel, Patricia will share with us how this new policy can allow the International Criminal Court to better capture the conduct and the nexus between trafficking and conflict-related sexual violence. You have the floor.
Thank you very much, Chloe, and thank you, Ambassador. Today, we launched the special edition of the Journal of Human Trafficking, Enslavement, and Conflict-Related Sexual Violence. And the title of the journal will be The Nexus Between Human Trafficking, Slavery, and the Slave Trade. And this nexus is important. As Chloe said, on Monday, we launched the first policy on slavery crimes of the International Criminal Court, and how this policy actually can be a companion to this special edition of the journal is that we try to describe in detail what are slavery crimes, what is slavery enslavement, what is slave trade, and what is sexual slavery. And this special edition really is comprised of a series of articles and interviews by United Nations mandate holders, academics, practitioners, policymakers, and civil society advocates that put together what is trafficking and what are the slavery crimes, and where do they dance around each other, where do they hug, where do they step back, where do they fall down. Sometimes they stumble and fall into each other. But it's because we have two very earnest communities of persons who are advocating for an end to sexual violence and armed conflict, and for an end to trafficking and slavery crimes. So we saw the policy as entering into a conversation, and the conversation is centered within the journal. The special edition explores and promotes really the safeguards that are contained in It's correct, I believe, as the ambassador said, complex legal frameworks of slavery crimes and trafficking in persons. So I'll start by describing a bit of that conversation. Trafficking in persons, a transnational crime, is defined in the United Nations Palermo Protocol, and it requires broad interstate cooperation to combat this conduct that's closely in nexus to organized crime. And the organized crime might not necessarily in and of itself be an armed conflict or an attack against the civilian population, but trafficking in women and girls is part of organized crime. In addition, trafficking in women and girls specifically is a human rights violation under Article 6 of the Convention on the Elimination of Discrimination Against Women. So we understand that the trafficking framework comes out of international conventions that were related to first white slavery conventions, and then are related to organized crime conventions, and then are part of human rights treaties. Then when you turn to the other side of a complex legal argument, you see that slavery and the slave trade have their own different treaties, and they're also customary based, and they're use cohesion based. They're international crimes, and in addition, they're human rights violations. You find that they have a treaty basis in the 1926 Convention and the 1956 Supplementary Slavery Convention, and you find their human rights basis in Article 4 of the Universal Declaration of Human Rights and Article 8 of the International Covenant on Civil and Political Rights. They are non-derogable human rights. But each of these legal regimes is distinct, and yet, as one of our authors will talk about, there are moving parts. One can provide potential evidentiary conduct for the other. At times, they overlap. Accordingly, their specific aims are clear, but they can be misunderstood, and they're often confusing, conflated, and their complementary jurisdictional venues are underutilized when they are used. So consequently, sexual violence survivors of conflict-related crimes and slavery survivors sometimes are both slavery survivors and trafficking survivors. But usually, they're almost fully deprived of recognition of both legal regimes at the same time. So they have a problem to access and have their harms fully characterized and have justice and redress fully brought. We're going to go into the reasons why with the different presentations. But let me just diverge a little bit into the Rome Statute in Article 7, which has the definition of enslavement under crimes against humanity. You will note that in that definition of the exercise of all of the powers attaching to the rights of ownership, it also includes the word in the course of trafficking in persons. This adds to the confusion. Does that mean that enslavement under the Rome Statute is the same thing as trafficking? And we'll have some of our panelists respond and explain that to us. In reality, the ICC doesn't have jurisdiction over the transnational crime of trafficking, and that there is imprecise drafting in the ICC. But it is important that the practice of policy making, that those who actually make the laws understand the fault lines of both the Rome Statute and some of our trafficking laws. So this special edition aims really in earnest to unravel this confusion between slavery, the slave trade, to a lesser extent sexual slavery, from trafficking in persons, so that we can accurately define, acutely interpret, and appropriately use their specific safeguards. It's for the benefits of survivors and victims whom we might be in the future. So today, slavery and the slave trade and human trafficking are occurring in situations of armed conflict in the Ukraine, in Sudan, in the Democratic Republic of Congo, and in Ethiopia. As a matter of fact, armed conflicts accelerate human trafficking and create situations where slavery crimes fester. The slavery crimes can become structured, and we've seen this with the decades of enslavement used by the Lord's Resistance Army in Uganda or in the ISIS Caliphate in Iraq and Syria. Therefore, today's conversation is not theoretical, it is practical. It's done to rectify both the pursuit of human trafficking as a transnational crime and the slave trade and slavery as international crimes. We'll examine trafficking from an interstate point of view by Amy Comrie, who is with us. We'll examine it from a national court perspective by Alexandra Lilly-Cather, and from an international law criminal perspective of the Rome Statute by Professor Jocelyn Gitgen-Kestenbaum. But we'll also hear about this wonderful report and its reception, I understand, by the United Nations in Vienna. So we begin our conversation today to disentangle so that we can put back and fortify. I turn it over to you, Chloe.
Thank you, Patricia. And now I'll welcome Anne-Marie de Brouwer and F.J. de Volder, who are co-founders of Impact, the Center Against Human Trafficking and Sexual Violence in Conflict. They're also the co-author of the UN Nexus report, which is forthcoming on human trafficking for sexual exploitation and conflict-related sexual violence, which focuses on Ukraine, and also co-author of the Disentangling to Fortify article in the journal, which you just mentioned. So I'll start with you, FJ. You're one of the co-authors, as I mentioned, and I'd like to ask you maybe to elaborate a little bit on the findings of the report with respect to the notion of the nexus between conflict-related sexual violence and trafficking in person.
So thank you very much. First of all, we are very happy to be given the opportunity to present the results of the work that we did, and that actually the SRSG Patton and her team kindly allowed us to work on. So it's Anne-Marie, Leah, who is sitting there, and me. So you already gave some of the context about the research, but let me elaborate a bit further. As mentioned, in 2016, there was already the recognition of the UN Security Council about the nexus. But then these crimes actually had developed in its own right. So they actually they developed in silo with different crime elements and also frameworks to actually address them. And this actually led to both at the international and the national level quite some misunderstanding as to about how the crimes are connected and how accountability can be established for the both. And actually, the war in Ukraine created new momentum in the discussion. And this is because the Ukrainian government, very early on in the war, actually acknowledged the nexus and the importance of establishing accountability for both crimes at the same time. But in the meantime, we also saw a record number of Ukrainians actually fleeing to other countries. And that also meant that potentially a lot of victims of conflict-related atrocities also moved abroad. So in order to see whether we can establish accountability and to judge the rule of law response, we did not only we had to look not only in the context of Ukraine, but also into the countries to which a lot of the Ukrainians have fled to. So therefore, the study did not only look into the nexus, but also in the national rule of law response and awareness of national stakeholders in 20 countries in total, including Ukraine, and 14 countries who've actually received most Ukrainian refugees up until that point. And we also included some countries that actually have a past history of conflict and high prevalence of these crimes. So, but we will come to also that survey in a minute. So then to move to your question about our findings in relation to the nexus, we actually looked first to these crimes in silos. So actually CRSV as an international crime, looking with the base in the Rome Statute, and then also human trafficking, and then with the starting point of the Palermo Protocol. And then we actually took them together and see, okay, where are they similar and where are they different? So, well, in due time, people can see it more in detail in the report, because there we detailed it quite well. But for now, some of the common features that we would like to actually show is, and some of them are already mentioned, is that both crimes actually are crimes that can be categorized as sexual, gender-based violence and or reproductive crimes, for starters. Then you see that the underlying factual circumstances of the crimes actually can be similar. So that means that they can be charged under, under both crimes. Both crimes may involve financial gain. So with trafficking, it's an element, but in particular for the CRSV crimes, it also of sexual slavery and forced prostitution, it is the same. Well, both crimes can happen in conflict and post-conflict situations. Let me first. But there are also quite some similarities as far as the perpetrators are concerned, but also the victims. And you see also quite some similarities in the psychological impact of the crimes for the victims concerned. And finally, you see that the challenges that are there as far as investigation and prosecution is concerned are also quite similar. But there are also quite some important differences that need to be highlighted. So for one, and it was already also mentioned by our moderators, is the status of the crimes. So there is a huge difference. The fact that CRSV is an international crime and human trafficking or trafficking in persons for sexual exploitation is actually a transnational crime. And that this means that even though trafficking in persons is mentioned in the Rome Statute, it is only a way of actually, the conduct of trafficking in persons actually can be used as evidence to prove the international crimes of enslavement, sexual slavery, or forced prostitution. But trafficking in persons is not an international crime as such. And that is something that you see that is often conflated in practice, that trafficking in persons in and of itself is an international crime. Other differences include whether or not the crimes need to be materialized, issues around coercion and lack of consent. What is also different and quite important is the level of victims' rights that are attached to being a victim of crime of conflict-related sexual violence or trafficking in persons. And finally, also you see that some crimes might actually be without being having the elements of for trafficking in persons for sexual exploitation, still amount to conflict-related sexual violence, while you also have crimes that are crimes of, for example, for conflict-related sexual violence crimes like forced sterilization that you actually rarely see in a trafficking in persons context. So I think that's, that is, in short, some of the findings about the nexus that I want to highlight.
Thank you very much. I'm going to turn to Anne-Marie now and ask, could you please explain your findings on the adequacy of the legislation and the prosecution practice in the jurisdictions that you surveyed?
Yes, thank you, Patricia. Yes, so in the report, we actually looked at 20 countries in total, and we looked at the laws and the prosecution practice in those 20 countries. And what we see is that for the laws, comprehensive legislation, up to standard legislation on both CRSV and TIP-S, trafficking in persons for sexual exploitation, is very minimal. We found only 9 out of 20 countries, in fact. And although all these countries, in fact, have legislation on TIP-S, most of the times it doesn't refer to conflict, with the exception of Ukraine and Moldova. And even, of course, it's not a necessity to actually prosecute TIP-S in conflict without having that reference. It makes it easier to overlook also the fact that TIP-S in conflict can actually be prosecuted. Furthermore, fewer countries, only again then 9 out of the 20, have international crimes legislation on CRSV in place, which is up to standard, complying with international standards such as the Rome Statute. If we then look at the prosecution practice, we see that even where there is appropriate legislation in place for both CRSV as international crimes and TIP-S in conflict, these provisions are still rarely used for either one of the crimes, and even where prosecution is in place for either crime, the conviction rate is extremely low, even though, of course, there is progress in this area. But in fact, to date, there have not been any prosecutions for CRSV and TIP-S in conflict at the same time. So for these crimes arising from the same underlying conduct, or for the crimes of CRSV and TIP-S in conflicts when they take place in a sequence. So we are still very much at the beginning, we would say, of prosecuting these crimes and their nexus at the same time. There is, however, a value in charging and prosecuting CRSV and TIP-S in conflict cumulatively, we would say. But to date, national prosecutors do not charge the two categories of crimes cumulatively. And doing so would, however, better capture actually the unique nature and the unique criminality of both crimes as well as their nexus. Instead, prosecutors typically prefer charging the crimes in silo or in a way which does not focus on the sexual nature of both crimes. So, for example, charging rape as a crime against humanity and human trafficking for labor exploitation. What is also important is to realize is that there are also other prosecution possibilities when dealing with a limited legislative framework on the national level. So, for instance, prosecutors could make use of charging one crime and ask for aggravating circumstances for the other crime, recognizing the nature and severity of the other crime and leading to a higher sentence, especially in jurisdictions where cumulative charging is not an option. Another idea would be that prosecutors use indicia of TIP-S to prove charges of sexual slavery or enslavement as a crime against humanity. And in this way, the nexus between TIP-S and CRSV crimes also are shown in the international crimes of enslavement and sexual slavery. Or a third option is that prosecutors could charge the related crimes to CRSV and TIP-S crimes, which also touch upon the nexus between CRSV and TIP-S, such as slavery and the slave trade. But even we can think of sexual terrorism, where CRSV and TIP-S are being used as a tool to commit terrorism. And we can even think about the sexual and gender-based crimes that are prohibited in national jurisdictions in peacetime situations, even though it's not ideal, but it can still be an option. So these crimes may all actually be penalized in the criminal or sometimes even the military codes of national jurisdictions and could be useful in the absence or in addition to good CRSV and TIP-S legislation. However, nevertheless, without comprehensive legislation in place, prosecution of CRSV, TIP-S and their nexus will really remain a challenge. And it's recommended that the UN model legislation on CRSV and human trafficking should actually be used to guide national jurisdictions on the development and implementation of national legislation to actually criminalize CRSV and TIP-S. And as there is at the moment no clear guidance on how TIP-S, CRSV and its nexus can actually be charged, it would also be good to have more training and guidance in how to actually do that. So that's for now.
Thanks a lot, Anne-Marie. And going back to you, FJ, if you can maybe, so part of the study was also looking at perception surveys and measuring the awareness of the local stakeholders and those who are meant to actually implement part of the political commitment made in the Security Council resolution. Can you maybe tell us a bit more about what came out of that perception survey?
Yes, thank you for this question. So, yeah, with the survey, we actually explored the intersection between TIP-S and CRSV, focusing on national stakeholders' knowledge and awareness and perceptions of the nexus. And we did a quantitative and qualitative analysis and actually surveyed stakeholders across 5 sectors. So government, civil society, law enforcement, the judicial sector, and others. And well, I think at this moment I would like to share 6 findings that we found quite interesting. The first one is actually that we saw, coming from the survey, that gaps in awareness on the nexus in the political and the governmental sector actually could be linked to weak legislative and institutional national structures to tackle the crimes. So some countries, such as Libya, for example, significantly underperformed in identifying the cases that we brought forward on CRSV, TIP-S, and the nexus. Compared to other countries like Austria, Germany, Slovakia, Spain, Ukraine, and Switzerland. And this gap actually correlated to the weak national legislation and limited government investments into tackling these crimes. So it actually shows the importance of building these legal and institutional frameworks and strengthening the rule of law response, what you actually do as a team. What was actually also quite interesting is that political stakeholders across various countries demonstrated the lowest awareness of the importance of the nexus between CRSV and TIP-S for victims, which to us was actually quite a critical concern, because particularly given the role of political stakeholders in actually shaping policy and legislation. Another interesting finding was about the judicial sector performance. We actually expected them to do quite well, but they actually did significantly worse on identifying the cases. But this is probably because they over-identified cases because of and this might actually is also an important thing to consider when moving forward. Another important finding was that the psychological importance of legal recognition that was time and again stressed. So recognizing CRSV and TIP-S within the legal system is considered critical by national stakeholders for validating the experience of victims, which actually in turn supports also their psychological recovery. So this legal acknowledgement actually helps to reduce the feelings of shame and isolation, playing an essential role in post-traumatic healing, again underscoring the importance of investing in accountability. And then another, an important finding related to the fact that stakeholders consistently argued that there need to be equal rights for these victims. So that regardless of which crimes they actually experience, because what we see in the countries that we investigated, that there are much more rights attached to being a victim of TIP-S rather than CRSV, even though we said already that actually the conduct and the factual circumstances might be quite similar. So it's something that we really need to take into account and need to take action upon. And finally, there was a strong call also by the national stakeholders to increase collaboration between actually government, civil society, and international organizations to better address CRSV and TIP-S. So we actually saw that awareness is very critical in addressing these crimes, and that improved recognition of the nexus actually can lead to enhanced responses, greater accountability, and also justice for victims. Thank you.
Thank you very much for those findings. Turning back to Anne-Marie, based upon what we've just heard, I'd like to ask you 2 questions. Would you please share with us some of the report's recommendations to improve the rule of law and justice to victims of CRSV and TIP-S and their nexus? And then I'd like to ask you, or either Evgie, how do you see the journal that's examining this subject, how do you see the contribution that this journal could make together with the report? How does this advance the agenda?
Thank you. Well, based on the findings of the research, we have several key recommendations that came out of it, looking at the nexus between CRSV and TIP-S. With regard to 6 themes, there is more. You will read it later in the report, but I will just mention a few. So with regard to legislative reform, Not surprising, we say that there should be more international or better international crimes legislation that codifies the multiple CRSV crimes, including strong universal jurisdiction provisions, and also to have TIP-S legislation to be amended to refer also to in-conflict situations. And secondly, to also have the crimes that we discuss in the report, like slavery and slave trade, but also sexual terrorism, that they should also be comprehensively legislated so that there are different kinds of avenues to actually prosecute, depending also sometimes of the country that you are in. So the next theme was capacity building. We argued that there should be more investment in training for government officials, law enforcement, prosecutors, but also judges and NGOs on the nexus between CRSV and TIP-S. And secondly, to develop clear legal guidance on charging practices for cases involving conduct amounting to CRSV and TIP-S. Thirdly, to enhance cross-sectoral and cross-border collaboration to improve investigation and prosecution capabilities, what was already also mentioned before. The third issue is victim support, to implement survivor-centered policies focusing on reducing stigma, protecting victim privacy, and providing comprehensive support services. And secondly, again, as Eefje just highlighted, to really harmonize rights and protections for victims of CRSV and TIP-S to ensure equal access to justice and support for victims, including reparation. A fourth issue is the political advocacy, to increase awareness and advocacy within the political field to ensure proper legislation and resource allocation. And secondly, to promote the importance of recognizing the nexus between CRSV and TIP-S among policymakers. With regard to international collaboration, we argued to strengthen universal jurisdiction provisions to allow for the prosecution of these crimes across borders, and to enhance information sharing and joint investigations between countries, building on initiatives such as the Joint Investigation Team. With regard to research and monitoring, we argued to have more research on the impact of survivor-centered approaches and cultural and social barriers to reporting. And secondly, to also improve data collection and monitoring of CRSV and TIP-S cases, particularly those involving the nexus. So for the final part of the question, how can this report also advance the further agenda on all of these crimes, slavery, the slave trade, human trafficking, CRSV? So apart from what we just mentioned, that we wrote down also in the report, we want to highlight a few things. So first of all, the nexus between the different CRSV crimes and TIP-S, because we closely examined all the elements of these crimes and the frameworks they originate from. And this is often not always well understood by those working in the field of CRSV and TIP-S, because people either work on CRSV as international crimes or as TIP-S as a transnational crime. So we believe that this report, but also, of course, the journal, can be a start to bring these fields together, and which has already, of course, started, but it can help also in bringing it even more together and to discuss actually the differences and the things that are actually the same for all of these crimes. So we better understand actually what these crimes are all about. A second point that we would like to make is that, well, of course, there needs to be more done in terms of legislation and prosecution practice, including with regard to the nexus, and I think we have highlighted that in depth, so I will stop here. Thirdly, that we really need to search for a holistic approach and apply a holistic approach, that those working in the field look at the crimes in a holistic way to understand that, well, the different crimes are all really connected. CRSV tip as human trafficking in general, slavery, slave trade, and sexual terrorism, and that they can all be charged or play a role and can even be mutually enforcing. So that we really get actually rid of the silo approach, and that's where we are working on our own island, on our own crime, so to say, and that we actually break through that, and that we have this holistic approach, and that we also continue to educate ourselves on this issue and to work together on that. Fourthly, again, this also means that survivors of TIP-S and CRSV crimes need similar protection and support measures available to them when they try to access justice. And there should not exist something like shopping for the best protection avenue. There should be equal access to justice and protection and support, no matter where you are a crime of as a victim or survivor. So thank you for all the questions.
Thanks, Anne-Marie. As we get, this is quite a complex topic, but with very concrete, practical, and human impact. I'd like now to welcome Aimé Comrie, who's the chief of the Crime Prevention and Criminal Justice section in the United Nations Office for Drugs and Crime, and who's the author of Moving Parts at the Intersection of Trafficking in Persons, Slavery, and Slave Trade, which is also an article in the journal. Aimé, maybe can you explain to us, the ways in which trafficking in person, slave trade, and slavery overlap as concepts? What are some of the practical implications of those different legal contexts? I think, we're starting to see the picture emerge, but if you can hone in on that. And what do we need to do better to tackle these crimes in the context of conflict-related sexual violence?
Thank you, Ambassador, distinguished delegates, ladies and gentlemen. Thank you for the opportunity to address this important side event on the intersections between trafficking in persons, slavery, and the slave trade. So I'm very interested to explore how these interconnected crimes can actually, how our approach to them can actually strengthen our response and hopefully close the impunity gaps. Allow me also to thank the organizers of the event, Belgium, the team of experts on sexual violence and conflict, Impact, Patricia, Anne-Marie, and Effia for the invitation to join this special issue, and Chloe and Sophia for the ongoing partnership with the team of experts. And I note here that I'm actually speaking in my personal capacity and not representing the views of the United Nations where I work. I have to say, in my career, had the chance to work on both areas in a practical way. I've worked as an investigator of cases involving conflict-related sexual violence, particularly involving women and children, and later for the last 15 years working on trafficking in persons, from the development and delivery of technical assistance to criminal justice practitioners. So I feel that these are actually in a way two babies of mine, I'm very attached to both areas. And while the crimes are really legally distinct, they share really a fundamental aim, which is to protect human dignity and freedom from exploitation. Indeed, as I titled the article, the article being titled Moving Parts, the relationship is very complex and fluid, and I have to say I struggled a lot in writing the article because I kept being, running with this is intersecting, it's subsumed, it's different, it's, so it's different across different pieces of legislation. But the point here is that it's not an academic or theoretical discussion. We're not here to advance, legal doctrine, but to think about how can we bring justice closer to the survivors, and how can we respond better as an international community to bring, the remedies and the justice that survivors deserve. So from the trafficking side, the international legal framework, of course, the cornerstone is the UN protocol to prevent, suppress, and punish trafficking in persons, which I have to say is one of the most successful international treaties in terms of ratification, nearly universally ratified. And of course, then we have the prohibition on slavery and slave trade in its own instruments and as a peremptory norm of international law. Despite these, strong frameworks, we continue to see persistent impunity gaps and low conviction rates across all these three crimes. Recent jurisprudence highlighted the distinction and the overlaps between these crimes, and we've seen courts struggling also how to acknowledge these intersections and moving parts. So in my view, and what I put forward in the article, it seems that, in my view, all cases of slavery would likely qualify as trafficking persons, and maybe only some of the cases, the subset of cases of trafficking, would meet the threshold for slavery. And trafficking, on the other hand, would encompass a broader sphere of conduct, including also the softer means of exploitation, including fraud, deception, abuse of a position of vulnerability, and not only those involving overt force or restriction of movement. There has also been an evolution in understanding of trafficking over the years, which has, practical implications for investigators and prosecutors. So we see that traffickers increasingly rely on subtle forms of control, less on violence and on physical restraint. This is complicated because if you Google right now human trafficking, all of the imagery and the discourse you will see is around chains and handcuffs. And these stereotypical expectations of what exploitation look like are actually an impediment for investigators and prosecutors, and also for judges, to recognize trafficking when it comes, in their courtroom. And these are linked, I guess, to historical perceptions of slavery. But the bottom line is we have to recognize that if a person is vulnerable to slavery, slave trade, they're also going to be vulnerable to trafficking persons. The vulnerability is going to be the same, especially when we look at it through a gender lens, and even more so in the conflict context or post-conflict context, where the breakdown in the rule of law creates this fertile ground for multiple forms of exploitation. So that's also the complex part of the concept of modern-day slavery, which is an important advocacy term, and it helps to a layperson to explain what trafficking is, but then it's also can reinforce the stereotypical expectations again by focusing on kind of extreme cases where we see a mirroring with historical slavery. So that may, in fact, it risks us overlooking the subtle and devastating forms of exploitation that characterize a lot of modern trafficking that we see. So I think that with the aim of this work, this discussion, the journal, and all of us working together, the aim should be that we figure out how to be creative and use all the available tools, and to understand how these different crimes intersect so that we can, at the one hand, respect the different legal elements, but build stronger cases and deliver multiple avenues of justice for survivors. So I would say it's not really just a purely legal or technical challenge, but it's fundamentally about access to justice and reinforcing the delivery of justice in the field. Now, I think there were some questions. I think you actually already posed the questions, yes. So I'll just continue. Yeah. So when it comes to the specific area of the overlap, again, I think that I mentioned that most of the trafficking cases, all the slavery cases would likely qualify as trafficking persons, but not vice versa. And in the article, I've tried to put in some visuals, some different visual Venn diagrams to help us understand this possible overlap in different interpretations. I think the evidentiary challenges for investigating and prosecuting the crimes would be the same. So they often would involve vulnerable victims, challenges with witness testimony, and difficulties in linking individual crimes to higher level perpetrators. Should I keep going? Okay. And then in terms of the practical implications of the different legal concepts for victim survivors, so they would offer different paths for remedies. And I think here the UN Nexus report will be really interesting to look at the Ukraine context to see, this is a very live context. We see the relationship, I think, between the conflict and the organized crime. And to what extent is trafficking increasing in this context? And to what extent can we build something which is more mutually reinforcing when we're looking at the response to all the crimes? So that will be, I think, very, very interesting. What's interesting, I think, about the trafficking context is also the concept of non-punishment, which is not in the statute itself, but has been recognized as a soft law principle, which is very much endorsed in the UN system, and which states basically that victims of trafficking should not be charged for crimes which they're compelled or coerced to do as part of their trafficking experience. So this is an additional part of the legal framework for trafficking persons, which I think could be relevant in this context. When it comes to slavery and the slave trade, there could be additional avenues for accountability, especially when dealing with systematic exploitation by armed groups. And it may be interesting to look at slavery and the slave trade where there's issues around proving victim consent or non-consent. And here the focus is on the perpetrator conduct, which I think could be also very useful when it comes to trial. And in many cases where we don't have access to a victim or a victim is unwilling to go forward and to testify. To answer the last question, what do we need to do to better tackle these crimes? First of all, I think we need increased training and coordination across specialized units dealing with these crimes. Investigators and prosecutors should understand all three legal frameworks and how they can be strategically employed. This includes training on recognizing softer means of trafficking, such as abuse of a position of vulnerability, etc. And we also have to understand and promote the use of multi-count charging strategies. It was already mentioned there. And this is where I think we need training with all criminal justice actors, the importance of working with the judiciary, but also with the prosecutor. Secondly, I think we need some kind of, in the conflict context, we need dedicated multidisciplinary teams that can address all of these crimes holistically. Right now, in any given conflict setting, you will find teams that are working separately in silos on trafficking in persons, CRSV, GBV, human rights, gender, children, etc. So we need to somehow, in the practical conflict context, bring these together in some kind of task force where these teams can also ensure that if they're collecting evidence or supporting the collecting of evidence, it will be done in a way which can support all the relevant charges. I think that would be very key. We also need to have better understanding and investigation of the links between organized crime and armed conflict. So if we're looking also from the data perspective to better understand that, but how can, if there are investigations and prosecutions happening for international crimes, how can national actors be strengthened at the same time in parallel to tackle maybe a wider crime base that will not be covered by an international criminal investigation or prosecution. And lastly, we need to adopt more victim-centered approaches that recognize the totality of survivors' experience and provide comprehensive support services, including immediate assistance, long-term recovery support, access to legal aid, and protection from re-traumatization through multiple legal proceedings. So in conclusion, I would just say that this is fundamentally a really important challenge, a challenge to us as practitioners, as policymakers, to really come together and make this work in this important conflict setting, and that our success will not be measured, I guess, in terms of the different legal frameworks that we're monitoring and creating or sustaining, but how we can really bring justice to the victims. Thank you.
Thank you. You've not simplified, but you so lucidly describe a complex system that I really appreciate the way that you break it down, but also showed how we can work together. I'm now going to turn to Jocelyn Gettin-Keskenbaum, who's professor of law at Cardoso Law School, and she wrote the article, All Roads Lead to Rome, Combating Impunity for Perpetration of Slave Trade and Slavery Crimes, within the special edition. So Jocelyn, in light of what we've heard, can you tell us more about your article and describe some of the specific international crimes that you feel are missing from recent treaty law, whether they've been established or they're developing, such as the draft articles on the crimes against humanity and the Rome Statute, and how does the absence affect the justice options that might be available to survivors? But maybe in connection with that same question, I note in your article, you also discuss the ways in which the Rome Statute bifurcates slavery into separately enumerated crimes against humanity, and sexual slavery is slightly apart from enslavement. And why or does that lead to any type of factual incompleteness or possibly discriminatory results?
Thank you. So a warm thank you to Ambassador Bell, and thanks to Impact and the UN team of experts, especially Chloe, Sophia, Jimmy, and to Patty, Ifya, and Anne-Marie for putting together this special issue and panel event to discuss really important and timely topics that really do have strong effects on the ground, as we are seeing. So first, what crimes are missing in present-day international treaties and draft treaties that address international crimes? I like that you called this, or your editorial, the disentangling to fortify, because even within enslavement crimes, we need to disentangle in order then to be able to use all potential avenues for redress. And I say this because we are missing some crimes under the Rome Statute. In the war crimes provisions, for example, they include an enumeration of sexual slavery in both international and non-international armed conflict. But slavery and the slave trade are not listed as war crimes under Article 8, neither in non-international nor in international armed conflict. So we don't have those particular crimes that we can call upon in the Rome Statute. Slavery and the slave trade are two, as Patty said, of the oldest crimes under international law. They're not new, so the fact that they're missing is also starkly an oversight, potentially, in the Rome Statute itself. These prohibitions date back to the 1926 Slavery Convention and the 1956 Supplementary Slavery Convention. And these, as Patty mentioned at the beginning of this panel, are Jus Cogens norms requiring erga omnes obligations of states. They are also specifically customary and treaty international humanitarian law prohibitions. You see under Rule 94, for example, of the International Committee of the Red Cross study that's applicable in both international and non-international armed conflicts. That Rule 94 includes both the prohibition of slavery and the slave trade. They are also enumerated as war crimes in Article 4.2.f of Additional Protocol 2 to the Geneva Conventions relating to non-international armed conflict. And then turning to crimes against humanity provisions under the Rome Statute, under Article 7, it enumerates enslavement under Article 7.1c, and then separately enumerates sexual slavery under 7.1g. There is no enumeration here either of the slave trade as a crime against humanity, and the slave trade here is a treaty-based and customary-based international crime, and again, Jus Cogens, and so it's also been recognized specifically as a crime against humanity, as stated most recently in paragraph 10 of the Declaration of the EU CELAC Summit of 2023. Some acts that could constitute acts of the slave trade are found in a non-exhaustive list under the crimes against humanity of enslavement in the Rome Statute, but these acts would require proof of the exercise of powers attaching to the right of ownership over a person, which is the definition of slavery enslavement. And the slave trade crime, a separate crime under international law, does not require such exercise of powers of ownership. And there's also a mention, as was mentioned, of trafficking in persons, but as we've understood from our panelists, human trafficking is a transnational crime, not an international crime. So trafficking is conduct that indicates or provides evidence of enslavement, but the international crime is the slave trade, defined as bringing a person into or maintaining a person in a situation of enslavement, which again is missing from that crimes against humanity provision of the Rome Statute. And these omissions at present are replicated in the draft articles on prevention and punishment of crimes against humanity, which will now very graciously move forward in the treaty negotiation process. And Patty, you also asked then what the consequences of these omissions for justice and accountability for survivors of slavery crimes would be. For the Rome Statute, the consequences, I would argue, are pretty serious because under Article 21, the International Criminal Court does not have jurisdiction over customary international law crimes, and therefore these crimes do escape legal characterization as such. And victims, survivors are not able to receive then the complete redress for slavery crimes, especially for slave trade harms, but even for slavery harms when they do not include acts of a sexual nature in conflict settings as war crimes. In April 2023, the permanent mission of the Republic of Sierra Leone to the United Nations announced an intention to submit revisions to the Rome Statute of the ICC to include provisions for the slave trade as a crime against humanity, and recommended that the General Assembly also include slave trade as an enumerated crime in the draft articles on prevention and punishment of crimes against humanity. and pointing specifically to conduct criminalized as other inhumane acts of forced marriage and the euphemism of bushwives, Sierra Leone's representative condemned the impunity for conduct that included the repeated redistributions of victims to fighters, also as acts of the slave trade. So the proposed revision to the Rome Statute, along with the changes to the war crimes provision, would fill these critical accountability gaps in international law. And Patty, your second question, you and I have actually articulated some of these points before, and Lily, I also want to acknowledge that you and I, and even I see Magali in the audience, have made some of these points in other contexts, and including most recently in relation to the Nguyen case. The bottom line, and here's where I get professorial, is to remember that historically and conceptually, sexual slavery is slavery. I'll say it again. Sexual slavery is slavery. Sexual slavery is enslavement. And the Rome Statute separately enumerates sexual slavery, and this was done to visibilize sexualized violence occurring in the context of the course of enslavement. But it carves out some acts from the broader category of enslavement as a crime against humanity. And what this has led to thus far in the case law is what I would say erroneous interpretations of slavery crimes when allegations include certain acts of a sexual nature. So extracting sexual slavery from enslavement in the Rome Statute, in addition to making the proof of causing a person to engage in an act of a sexual nature an additional element or burden under sexual slavery, instead of having it be the indicia or evidence of exercise of powers of ownership over a person, which is under enslavement defined in the Rome Statute as slavery, has backed the court into this kind of historically ahistorical and factual mischaracterization that sexual slavery is a more specific form of enslavement, and in finding that enslavement is in the abstract entirely encompassed within sexual slavery. And I'll encourage everyone to go to the slavery crimes policy. There's this excellent Venn diagram that is within the policy. And you'll see that in the diagram, enslavement is the crime that encompasses sexual slavery. And so we are seeing this sort of reversal happening conceptually, but in reality, this is leading to some victims being treated differently if they have, within the factual circumstances, acts of a sexual nature. So I would propose that the more precise historical and factual analysis leads to the conclusion that conduct criminalized under sexual slavery is somewhat redundant, as it constitutes criminal conduct that's already outlawed by the prescription of enslavement. And so in other words, when someone's sexual autonomy and sexual integrity are subjected to ownership, enslavement or slavery exists, and that's regardless of whether the perpetrator causes the enslaved person to engage in an act of a sexual nature. The other point to make is that sexual slavery as a separately enumerated crime has been applied restrictively, and that leads to potentially discriminatory results. In Nguyen, for instance, the defendant perpetrated acts of a sexual nature and control of sexuality against all enslaved persons. So enslaved boy-child soldiers were forced to rape. Enslaved girl children, called ting-tings, were among other forced acts subjected to forced checking of the onset of menstruation to determine whether they had reached puberty and whether they were ready to be raped and groomed to become wives. Enslaved wives were controlled sexually through, among other forms of control, exclusive sexual access when in relationships in which they were subjected to rape. And enslaved ting-tings who later became wives were controlled sexually throughout their enslavement, and that's regardless of whether they were subjected to rape. Nguyen, therefore, directly and indirectly exercised powers attaching to the right of ownership over all of these enslaved persons' sexuality, sexual integrity, and sexual and reproductive autonomy, whether or not they were subjected to rape. The court, though, narrowly interpreted sexual slavery by really focusing solely on heteronormative male on female rapes in the context of the abductions and distributions. In enslavement situations, the threat of sexualized violence and the total control that perpetrators have over victims' entire beings is present throughout the situation of enslavement and is an inherent part of the exercise of powers attaching to the rights of ownership over sexuality, sexual integrity, and sexual and reproductive autonomy. And so while the Angwen court recognized this artificial separation of status between ting-tings, so those were the girls who were domestically enslaved, and so-called wives, the women and girls who were sexually enslaved, as a prohibition of sexual relations with ting-tings, the Senior Brigade in this situation with the LRA soldiers frequently raped both wives and ting-tings, and thus the threat of sexual violence was always present, whether the individuals were enslaved or sexually enslaved, but this constant threat of harm as exercise of powers of ownership rights includes all slavery in situations, and that was left unredressed. The misconceptions that enslavement primarily criminalizes the general deprivation of liberty, forced labor, or non-sexualized violence perpetrated against enslaved persons is this restricted interpretation then of enslavement on the one hand, and then the crime of sexual slavery primarily criminalizes in the practice rape and rape-like acts in the enslavement of mainly women and girls. And so we have to think about how we disentangle and how we fortify the enslavement crimes themselves, because those who can prove exercise of powers attaching to the rights of ownership, they can do this in myriad ways, and they don't necessarily only have to do this through proving that they were held out or caused to engage in an act of a sexual nature. And I'll stop there, and maybe we have time for questions.
Thank you very much. That seems like a big knot to disentangle. I guess you're trying to make us understand that enslavement in and of itself is sexualized.
Enslavement is sexualized.
Right. Okay, I'm now going to turn to Alexander Lilly Cather. Lilly, she's a co-founder of the Emergent Justice Collective and the author of one of the articles that's called The Adjudication of Slavery Crimes Against the Yazidi by German Courts, Evolving Jurisprudence and the Need for Rectifying Legal Amendments in German Law. So, Lilly, my question to you is that your article engages with prosecution strategies employed by German prosecutors building cases about crimes committed against the Yazidi. Can you explain to us how the different legal regimes interacted during this case-building phase and how prosecutorial strategies have evolved over time? And then my second question is, finally, what lessons do you think investigators and prosecutors can learn from these cases moving forward?
Thank you so much for the questions, Patricia, and allow me also to thank Belgium, the UN team of experts on sexual violence and conflict and impact, for convening what I believe is a really timely discussion that really allows us to expand, but also to deconstruct professional silos. And I'm very grateful to Patricia, Anna-Marie, and Evie for the invitation to be part of the special issue, and I'm extremely humble to share the panel with such a series of distinguished experts. To explain a little bit the methodology of the article I authored, so I studied the available jurisprudence at the time of writing of cases that dealt with crimes committed against the Yazidi religious and ethnic minority by ISIL. These cases have been adjudicated, as mentioned, by German courts and specifically higher regional courts under the principle of active personality if a German national was involved, or in the alternative under the principle of universal jurisdiction. Rather than focusing on the initial charges that were put forward in the arrest warrants and the indictments, I focused on what I could find in terms of factual description of acts that could constitute slave trade and slavery, and I aim to analyze how such acts have been legally characterized across the different cases against both adult men and women. And for context, for those of you who are not familiar with the judgment that are only in German and only partly available, the absence of the slavery crimes in the early cases
was met by really a prevalence of counterterrorism and human trafficking charges in the initial indictment. And in addition to this, they were met by significant challenges that are inherent to investigations and prosecutions under the active personality and universal jurisdiction principle, namely that there are inherent logistical differences such as resource constraints and lack of access to witnesses, but also the actual crime side, but that there are also very real social, geographic, and cultural differences and distances between third states that prosecute the crimes and the location in which, of course, the crimes were committed. The good news is, however, that over time, the prosecutions really recognized the varying and in part significant roles and involvements of both adult men and women that are perpetrators of institutionalized slave trading and slavery systems committed against Yazidi women and children of all genders. And for context, Yazidi women and children were often multiple and within cycles slave traded and enslaved. That was also accompanied and or followed by the commission of further gender as well as age-specific international crimes committed against them. And I really carried out this review from a practitioner's perspective. I'm not an academic. And also with the recognition that the Yazidi ethnic and religious community, as all slave-traded and enslaved persons, ought to receive adequate redress and protections under all legal frameworks. That is the international crimes of slave trade and enslavement, as well as the transnational crime of human trafficking, as mentioned. What I learned, and this should be really an inspiration for others, is that German prosecutors did not shy away to creatively and also bravely grapple and pursue legal accountability for acts of the slave trade, slavery, and human trafficking under various legal regimes available to them. Concretely, in the German context, they used the German Criminal Code, and under that code, there were counterterrorism charges and human trafficking charges brought, but also ordinary crimes of rape and deprivation of liberty. Another legal framework that was used was the Code of Crimes Against International Law, and specifically enslavement as well as persecution on gender and religious grounds. For context, there was at the time, now there is, at the time there was no sexual slavery as a crime against humanity or war crimes under that code, but there was a recent amendment in June this year. So what I can say as kind of like a summary conclusion is that the centrality of the criminality of the slave trading and slavery system as a central pillar and also foundation of how ISIL could implement and perpetrate its religious and gender ideology emerged factually and increasingly also legally over time. And this was really guided by the increasing evidence that was gathered. And I put forward that although it may not have been ideal to start through the counterterrorism lens, and that by itself would have been a reduction as well as a misrepresentation of the harms that were suffered, I think the initial counterterrorism and human trafficking charges allowed over time to expand a broad evidentiary base that allowed for a more concrete legal characterization to follow. Why we have that, I will go into a little bit later. To answer the first part of your question on case building, for those who are unfamiliar with the German context and specifically the investigations against the Yazidi minority, so the Office of the German Federal Prosecutor has been conducting what it calls a structural investigation proceeding against unknown members of ISIL on suspicion of having committed crimes under the Code of Crimes Against International Law already since the 1st of August 2014, so basically the moment the crime occurs, and that within the structural investigation proceedings, there are different branches of focus of other investigations. And one of the focus of these proceedings have been crimes committed by ISIL against the Yazidi in the Sinjar district from the 3rd of August 2014, involving all international crimes, genocide, crimes against humanity, as well as war crimes. And it's really under that umbrella that further charges also emerged. In terms of evolving prosecutorial strategy, that is very gendered. I take you 2 years later, starting in 2016, and it really started with a few cases against cisgender adult men that were either returnees or people who applied for international protection. And their charges were mostly concerned with support of and membership in a terrorist organization abroad, but also a significantly smaller number was concerned with the war crimes of killing or cruel or inhumane treatment of persons to be protected under international humanitarian law. A few years later, in 2018, women and children either returned or were repatriated or also applied for international protection in Germany. And these were women and children that formed part of ISIS and lived under the ISIS rule. And initial charges against women were support of or membership in a foreign terrorist organization abroad, as well as violations of the War Weapon Control Act, essentially using or owning weapons that are outlawed, as well as the war crime against property. And other observable trends in the initial charges were really violations of the German criminal code, so the domestic code, for crimes committed by women against their own children, mostly that they brought into ISIL territory and thereby into ISIL ideology. And these charges include the violation of the duty of care and education, abduction of minors, and involuntary manslaughter. What, from my point of view, remains unaddressed in the initial charges, but also until the present day, is that crimes against persons of diverse sexualities and gender identity, as well as crimes committed against non-Yazidi children of ISIL, which were enslaved in part by their own guardian as well as within ISIS in gendered ways, have not been really put forward in the investigations and prosecutions we saw thus far. And I think there's also room, while we have this discussion, to really look from an evidentiary perspective more into the historical as well as social structures that allowed for the slave trading and slavery system to be established in this way in the location in which it occurred, and in that very context it was Iraq and Syria as well. Bringing some more hopeful and positive news, we have recent cases, the Sarah O case, the Tal Al-J case, and the Nadine K case, respectively, concluded at the Higher Regional Court of Düsseldorf, Frankfurt, and Koblenz. And there we see an evolution towards an increasing use of international crimes charges, specifically enslavement and persecution as a crime against humanity. Again, sexual slavery was not charged because it was not a crime available at the time of the trials. What is interesting is that, and I want to mention it here, but it may be a bit complicated for those outside, but I think it connects to our call to use all legal frameworks available. But in German jurisprudence, it was clarified that the provisions of the Code of Crimes Against International Law, so essentially enslavement and persecution as a crime against humanity, displace the general criminal offenses in the German criminal code by means of lex specialis. And lex specialis in this situation was evaluated if they specifically criminalized the commission of general offenses in a certain context, and that a widespread and systematic attack can be understood as such a context. So what that means for the Sarah O case, for example, is that trafficking and deprivation of liberty charged under the German criminal code took the back seat to enslavement as well as persecution as a crime against humanity. Not because they didn't occur, the court recognized that such violations occurred, but the specificity of the context in which these harms occurred gave enslavement and persecution the front seat of the bus. And now I conclude with several factors that contributed to evolving jurisprudence, and I think among them are public and non-public advocacy with prosecutorial authorities, but also in the context in which the litigation occurred, that underline the importance of appropriate and precise legal characterization of such harms. We also had the privilege of openness and increased international crimes expertise among the Federal Police and Federal Prosecutor's Office. And my last point is that victim representative started to file motions that requested recharacterization of charges and or additional international crime charges that led us to the judgments that we have right now. And to explain how that was possible, German procedural law allows victims of any criminal offenses to join the persecution as joint plaintiffs. And as joint plaintiffs, they have rights before and during the trials, and among them is the right to request additional or a recharacterization of charges.
Thank you. Chloe, you have the floor is open for questions.
Yeah. Hopefully we haven't confused you even more than you were at the beginning of this conversation.
And we didn't plant any questions in the audience either. Okay, so Magali. Okay, let me repeat the question if you didn't hear it. Magali, who's from the Court of Central African Republic, Magistri, is asking, after the Ongwen observation that you made, was there any change in the way that the Office of the Prosecutor charged sexual violence in the context of enslavement? And the answer to that is yes. In the current indictment, or the charges that have been raised against Joseph Kony, we have included the sexualized indicia of enslavement. That conduct is now under the term of enslavement and not under sexual slavery. But those charges have not been confirmed yet. So we'll be looking forward in the next 4 to 5 months to see if the Chambers confirms that enslavement itself can contain indicia that is based upon sexual or gender-based violence.
I think we have time for one more question before we have to go to close. Or comments are welcome as well, by the way.
You know, I would like to make one comment, and I think that's very good, this idea of cumulative charging that's not just with international crimes, but with the domestic criminal code, as we can see that might have been part of not the error in Germany, but the learning process. And also that certain crimes, such as trafficking, might have a much wider evidentiary base because it's related to organized crimes, whereas the international crimes might be related to militia states, and they weave in and out of each other. I'll just tell one anecdote within 30 seconds, is that I had a case back at the Yugoslav tribunal, the Kunarac case, Focha, and when speaking to the accused once, they had asked him what did he do during his non-armed conflict days before the war, because we found that he had been enslaving women, and he basically said, well, I was a pimp. I used to run women. So we really see how these factual intersections might just reveal themselves in armed conflict in a different way, but are still present in non-armed conflict or post-armed conflict situations. Right.
Thanks, everyone, for this incredibly intellectually provocative and challenging panel. You can find a lot of, if you haven't reached full clarity yet, you can find all of the articles referenced into the journal, which is also made available online for free at the moment, as I understand.
Yes, until January 15th, and you can have a discount also if you use a certain code. So I think we should put that in the chat.
Yeah. So you're welcome to use the resource at the moment and deepen your understanding or check anything that may have sounded a little too complex to grasp in this panel. And you're also welcome to come back to us in terms of questions or comments or your own experience. I think we are trying to enrich this field and advance it, and we can only do it if all of us. And I think it was very clear from all of the intervention in the panel that this is a multi-dimensional issue. It requires stakeholders from different vantage points to actually come together to be able to move this issue. I think one of the things I wanna go back to is your point, Patty, from the beginning, which is this is not a theoretical conversation, even though the conceptual aspects are quite complex and needs, some refinement in terms of understanding and grasping the ability to articulate. But it is a very practical one, and I would say it's a very human one, because I think we heard through the interventions of everyone how this actually has an human impact on victims. And the recognition or the lack thereof of the complexity and the multi-layered aspects of crime is quite important. And if we are truly committed to having victim-centered and trauma-informed approach, I think we owe it to survivors and victims to really deep dive into this and help build this articulation between the various frameworks. And maybe one more point here, which is, a point also that was made quite forcefully, I think, by several speakers, is the issue of being creative in terms of the way that prosecutors use the various legal frameworks at their disposal, and being cumulative, so thinking complexity in how you actually are bringing forward the charges in cases, so that we can really, in the justice and in the accountability, capture the multidimensional aspect of the harm suffered by victim, rather than be expedient and maybe choose what's more the easiest way to do this. It's obviously quite complicated when legislative frameworks are not where we need them to be. I think, you made a very, clear case in terms of, some of the changes that should be considered, and the Sierra Leone proposal in terms of the Rome Statute. I think we heard also from Impact, the more domestic aspect of some of the legislative framework. It was quite striking, the results of the survey in terms of the number of states that have adequate national legislation. So the legislation part is quite important, and that brings me back to the role that all of us have, whether you're a policymaker, whether you're a victim advocate, whether you're a prosecutor, to actually do your bit to advance those issues. And it's quite important, and I think this is not something that will be the only types of crime that we're going to see as needing this types of approach. We are at a moment that I think we have seen conflict morphing, and we have seen intersectionality also of conflict and organized crimes. And the Venn diagram could also apply to how we are categorizing conflict. We come from very distinct understanding of conflict, whether international, internal, or criminal conduct. But the spectrum is a continuum. And I think at the moment, the legislative framework in which we operate are still quite circumscribed to understanding conflict as separated from the spectrum of violence. And what we are seeing in the 21st century type of violence and conflict is a continuum. And I think we owe it to the victims to be better at really thinking the complexity of that continuum of violence, so that we do not leave anybody out in terms of justice. And on that, I'd like to conclude and thank you for coming, and hope to see you again and engage with you in this continuing conversation.